mental and emotional well-being.
With those sorts of courses, is it kind of one of those things you get out of it what you put into it?
Yes.
And are you just going through the motions to get certificates, or are you still pursuing betterment?
No, I'm pursuing betterment.
Now we're moving into the closing end of things, okay? I know that there are some apologies that you wanted to make and some words that you wanted to say to the court. So now is your time and your opportunity to do that, okay?
Your Honor, to this court, if I may start with the Perry family. To the Perry family, no words can express the pain that I feel, nor will it ever take away the pain that you feel. But I want to say to you that I'm godly sorrowful, and I know it doesn't take back what has happened, nor does it negate what has happened. But I want you to know that I am so sorry for the pain that I've caused you. To Tabitha, I'm so sorry. I never meant to hurt you. And I pray that all of you guys will forgive me. But please know, I never meant for any of this to happen. To my family, I'm so sorry that I've taken you guys through this. Never meant to hurt or harm anyone. And I'm so godly sorrowful. Judge, I know what I did. I wasn't in the best health. And I know it doesn't take away what happened. But please, know that I'm godly sorrowful. And I ask that you extend grace and mercy.
That's all I have, Your Honor.
Cross-examination.
No questions.
Store, she purchased a gun in Sherwood, Arkansas. From the proof at trial, she's on camera, purchased the gun, giving the sales rep her ID, signing any paperwork that she needs. And then the defendant, when she was in Sherwood, Arkansas, drove to Memphis, which is over 2 hours from Sherwood, Arkansas, is 2 hours from Memphis. And so the court finds that, you know, the defendant's actions were deliberate. And although she wasn't found guilty of first-degree murder, her actions that she showed, and there was proof from Dr. Bidding that she had major depressive disorder, and also that she had some suicidal ideations. And that was the defense version of what happened. And obviously the jury rejected that. But also Dr. Bidding said that her conduct was, could be, even if you have depression, you can still be sequential, intentional, and deliberate in your actions. And it appeared that way to the court, because the defendant drove over 2 hours, went to the victim's home, sat and talked with the victim, shot Mr. Perry several times, emptying the clip. And when the police arrived, she was attempting suicide. But during the entire course of that, the defendant possessed a weapon. Nothing, you know, like Dr. Bennett said, I mean, she could still commit these actions even if she had a major depressive disorder. So the court finds that the nature and circumstances of the offense are serious. The victim was unarmed, and it really just comes down to the fact that the defendant said that the victim would not walk her to her car. And that, I mean, that's senseless, you know, senseless to kill someone because he would not walk her to her car. And although the victim was a pastor who did not treat her right and he broke her heart, a broken heart does not justify someone dying. It just does not justify someone dying. It was just senseless. When typically when this happens, the relationship is over. You know, both parties go their separate ways. But in this case, the defendant killed the victim because her heart was broken, and so the court finds that the nature and circumstances of this offense warrant a lengthy sentence. Again, the statistical information shows that 19 years is a typical sentence for a standard range 1 offender, in the court would give that some consideration. And looking at the nature and circumstance of the offense, the court is going to give that great weight for a lengthy sentence. Also, the court has to consider enhancement factors. And the first factor that the state raises is that the offense involved one or more victims. And the court finds that that factor does not apply. The fact that another person or persons are present when a crime is committed standing alone is not sufficient to trigger this factor. In this case, the 2 victims who were present in the home were Ms. Perry and Mr. Perry. And the defendant was convicted separately for her conduct for each one of those victims. And so the court finds that that factor is not appropriate in this case. The other factor that the state relies on is the personal injuries inflicted upon or the damage to the property sustained by or taken by the victims was particularly great. The court finds that it's not applicable to second-degree murder because it's inherent in the offense. It's an element of the offense. The injury was death, and so the court finds that that factor is not applicable. And then also the court finds it's not applicable to reckless endangerment because it has to be something that is over and beyond. Although the Ms. Perry said that she had pain in her shoulder, the court doesn't find that that is over and beyond what someone would be expected. The type of harm or injury that is greater than what is expected if someone was shot. So the court finds that that factor is not applicable to this case. Next, the state asks for the enhancement factors. The defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense. And the court finds that this factor does apply, and the defense concedes that it does apply. But the defense asks that the court not give great weight to this factor.